Welcome everyone to our YouTube channel Forensic Mart. Today we are here with a case study related to forensic science, the Sindhi alias Raman case. Appeal number of the case 65 of 1969. Date of judgment. State of Maharashtra versus Sindhi alias Raman, State of Dalwai on 4th August 1987. Court. Bombay High Court under the judgment of R.A. Jahagirdhar J. Bench. R. Jahagirdhar stated under judgment R.A. Jahagirdhar J. Sections. Here are some relevant sections. 44 of IPC, Section 342, Section 302, Section 428, Section 374, Section 465, Section 464, Section 105, Section 354. In that case, one Dhani Ram was the father of Leela Dhani Ram. His wife Somvati, his daughter Leela and his brother Babu Ram lived together in the same house. Indira was the appellant's sister. The appellant and his father suspected that Babu Ram was prone to making illicit approaches to Indira. On this account, the appellant had a long-standing grudge against Babu Ram. The motive of the attack by the appellant on Leela, a member of the family of Babu Ram. The motive for the attack on Parvati is not clear. Raghuveer was attacked because he tried to intervene. The defense failure was insanity. Since 1958, the appellant was art employee in the stores branch of the Northern Railway headquarters in Baroda House, New Delhi. In 1958 and 1959, he had altercations with the other clerk in the office. On May 20, 1959, his superior officer observed that he was prone to lose temper in no time. In his moments of excitement, he became dangerous and used to hit his colleagues with anything that he could lay his hands on. But at the time of his greatest excitement, he could not distinguish between right and wrong. After May 1959, he worked at his desk as a normal man. In March 1960, he again quarreled with another clerk. He was suspended and sent for medical examination. At this stage, he was suffering from mental illness. On October 12, 1960, he was examined by a psychiatrist who found that he exhibited symptoms of acute schizophrenia and showed disorder of thought, emotion, and perceptions of external realities. The psychiatrist said that was harboring certain delusions. The nature of the delusions is not stated. It is not proved that the appellant suffer from any particular delusion or hallucination. The appellant was put on a drug named Largicchile and was advised to join his duties. On resuming his duties, the appellant worked in the office in the normal manner. On November 25, 1961, and on the preceding night, the appellant complained that he was unwell and took medicine. But on the morning of November 25, he went to his office as usual. He was late in attendance and was marked absent. He applied in writing for one day's casual leaving, stating that he had an urgent piece of work at home. Nobody noticed any symptoms of mental disorder at the time. He left the office at about 11:30 a.m. and returned home alone at 1:45 p.m. He stabbed Leela, Parbati, and Raghuveer with a knife. He concealed the knife, and a search for it was proved fruitless. At 2:45 p.m., the investigating officer arrived on the spot, arrested the appellant, and interrogated him. He was then found normal and gave intelligent answers. On the same day, he was produced before a magistrate. His brother was then present, but the magistrate was not informed that he was insane. On November 27, he was interrogated by an inspector. The appellant was later remanded to judicial custody. On receipt of another application from his brother, he was kept under medical observation from December 6 to the December 23. On December 19, the medical officer noted that the appellant was indifferent to his surroundings and personal cleanliness. It does not appear that he was then insane. On it does not appear that he was then insane. On November 30, the appellant's brother filed the application before the committing magistrate stating that the appellant was insane at the time of the occurrence. Preoccupied in his thoughts, muttering to himself. Preoccupied in his thoughts, muttering to himself, making meaningless gestures, losing track of conversation, given to delayed and repetitive answers, and unable to give detailed account of incidents leading to his arrest. On December 23, he was declared to be a lunatic though not violent. The psychiatrist noted that the appellant had a relapse of schizophrenia and was suffering from disorder of thought, emotion, and loss of contact with realities. From his attitude and manner of talk, he was found to be aggressive. On September 6, 1962, the psychiatrist reported that the appellant was cured and was in a position to understand proceedings in court. The commitment order was made on January 4, 1963. The trial started in February 1963. The appellant was seen at the time of the trial. Forensic report. On the fact of this case, it was found by the High Court from the conduct of the accused, especially that his mind was disordered. He not only killed a third person, but he killed his own daughter for non-assignable reason. Therefore, it was found that the appellant knew the nature of the act, but he did not know that what he did was contrary to law. Or did he know that what he was doing was wrong? This was the correct exposition of the provisions contained in section 84 of IPC. If by the reason of unsoundness of mind a person is incapable of knowing the nature of his act, then the question of considering the other part of section 84 does not arise at all. There is a clear distinction between legal insanity and medical insanity. The medical insanity may be of various types, kinds of degrees. To what extent the medical insanity affects the cognitive faculties of a person will naturally depend upon the nature of that insanity. The person may be suffering from some form of insanity recognized by the doctors as such, but that form of insanity may not necessarily be the unsoundness of mind contemplated by Section 84 of the IPC, if dissipate the insanity which the doctor may find in a particular person. That person is able to recognize the nature of the quality of the actor for which he is tried, or if he capable of knowing that what he was doing was either wrong or was contrary to law. Then the benefit of Section 84 of IPC, if dissipate the state of mind of the accused which Dr. Parker found on the day on which he examined him, and assuming that this state of mind had set in by the day on which the incident took place, the accused was capable of knowing the nature of his act, and after the knowing the nature of his act, he was also capable of knowing that what he was doing either wrong or contrary to law, then naturally the accused would not get the benefits of Section 84 of IPC. Thank you for watching the video. For more such case studies, subscribe our channel and click on the bell icon so that you don't miss our upcoming case studies.